Thanks, everyone. I know it's getting quite late on a Friday sort of afternoon, so thank you very much for still being here. So hopefully my role is just to talk a little bit about sort of the UK inbound sort of elements to immigration and see how we're able to support your clients and looking at a couple of different trends, etc. A couple of things I just wanted to talk about first is just sort of PwC and the ability to be able to support clients from an immigration perspective. Some people are completely unaware that we've got this untapped incredible team. So we have around 2,000 immigration lawyers around the world within PwC, all within our own network, which helps to drive a lot of consistency in the way that we're able to support clients from a commercial perspective. And we service 174 territories around the world as well. So it is quite remarkable, and in fact we are probably the largest immigration network of any of its type. So a little bit of an untapped secret sometimes. So let me see if I can work this. Before we get on to sort of the nitty-gritty of the immigration, I think it's part of the strength of, I think, what PwC is able to do is that we have such incredible government liaisons all around the world because of being such a significant consultancy firm. And that really helps us to drive and support governments when they're looking at different challenges around the world. So in particular, looking at, the migrant crisis, PwC did a lot of work with the migrant crisis in helping to shape different propositions for the government. Our government liaison team globally is significant. So in addition to things like the migrant crisis, we also work with different governments to help support and strategise around different investment type options. But also we help to write, in some instances, the changes to a lot of the business immigration law that go on from time to time. Sometimes the good, sometimes the bad. But I think it's quite interesting. And it's important for us to have such a good knowledge in terms of the depth and breadth of everything across that immigration and migration brand, because sometimes it's so important for the left hand to talk to the right hand when we're looking at the different policies and processes that we're trying to achieve, not just for the high net worth individuals, but also for the migrants and the refugees, etc., that are currently, in dire need of some sort of support from a global perspective. So there's this other little thing called Brexit, which I know is very important from a UK perspective, and I find it interesting from a European perspective because the EU obviously do see it as something important, but probably not quite as high on the agenda as what Britain sees. One thing I do on a day-in, day-out basis is advise many of my clients around the different support or things they should be doing at the moment when they are looking at Brexit, because it is going to have an effect, particularly to the Europeans going into the UK and wishing to settle there and make that their home. At the moment, there is still a huge amount of negotiation that's still occurring with respect to that. Britain keeps coming out and suggesting more and more in terms of a refinement of how they're going to protect the existing European citizens living in Europe. And of course, Europe's saying that's not quite enough as yet. So I think we're getting closer, and certainly with things like there was a leaked white paper which showed a bit of an infrastructure of what the UK government is thinking in terms of how they are going to support the European citizens that are currently in Europe. And there was also a settled status paper which the government provided, which at the time when they first published it still had quite a few holes and questions in it. And the government now keep talking about different ways to be able to provide or clarifying certain things regarding that settled status. In fact, David Davis, who is the UK's sort of Brexit negotiator or Brexit secretary, has in fact last week come out and confirmed that European citizens who live in the UK at present and who have permanent residency will almost be flipped over into that settled status state in a nice, easy way. They've also said for Europeans who are not in the who haven't applied for permanent residency, that the process of settled status will be almost as easy as applying for a new driver's licence. Now, I don't know if anyone has a UK driver's licence, but I personally don't find it that easy. But at least it's within the right framework and attitude about making it simple, digital, and low cost. I still believe, though, that from a low-cost perspective, it probably won't be the same price as what it is at the moment from a government perspective. So at the moment, if you're European and you live in the UK, that permanent residency application's around £65. £65. But the government, I do anticipate, would increase that fee for the settled status. So it's important for individuals or European high net worth individuals who are looking to go to the UK to really understand what their position is at the moment to be able to stay long term, because we don't know if they've just arrived or about to arrive, how that's going to impact. There's still an element of unknown. We do know that the UK and the EU have now agreed, or both have ticked the box in terms of the 2-year transition. So it's during this 2-year transition time that we will see how the settled status rolls out, and also the framework of what the government will really do in terms of future movement of Europeans being able to live and work in the UK. The 3 sort of main things, if anyone does have clients, friends, relatives, or high net worth individuals that in fact have businesses that are in the UK, there's 3 core things that they should be doing at the moment with respect to their European workforce who are in the UK. So data. It's amazing how a lot of the clients that I work with don't know the nationality of their existing employee workforce. And that's actually really quite important. It hadn't been mandatory, right-to-work checks had been mandatory, but maintaining that data in a good format is going to be crucial, because there may be a cost element, there may be a mandatory requirement on employers to really make sure that their Europeans are registered for this settled status, and this is going to be something that you need to really understand, together with the skill set of those individuals. Are they low-skilled workers, mid-skilled workers, or high-skilled workers? Because it's very, very likely that the UK government will bring out a skill threshold in terms of Europeans being able to come and live and work in the UK. So just a few things to think about. The other good thing which we've been telling clients as well at the moment is just, in terms of permanent residency, for the Europeans that have been there for 5 years, there's still a real value in obtaining your permanent residency, even though they're talking about flipping it to this settled status. The couple of things I'll say about that is, one, we do know what the process looks like now, we do know what the document requirements are now, and we do know what the cost is now. The government have done a lot in terms of looking at how they streamline the existing permanent residency application. So it's gone from being an 86-page awful document to now quite a slick online platform with very much a reduced amount of documentation being done. So we're seeing applications being turned around in 4 to 5 months, which is still pretty good considering that they've got such a high demand at the moment. So the government are quite focused on making sure that we get them pushed through quite quickly. And the advantage of getting permanent residency now is twofold. One, it gives individuals a sense of that they have now had a true adjudication through the UK system that they have been, exercising their treaty rights for a period of 5 years. What we find in terms of these applications is people may have lived there for 20, 30 years, their children were born in the UK, but if they haven't got the right documentation, we're seeing refusals, and that obviously then creates a lot of bad will. Doesn't mean they're going to be kicked out of the country, but it's really important that you're able to evidence with the correct documentation that you have been exercising those treaty rights. And of course, once you've got permanent residency, which is mandatory, they can then apply for British citizenship. And that's also really important for a lot of individuals who have had children born in the UK who want to make sure that their children have an option of citizenship at a later stage. So 2 good reasons in terms of why we think it's still important for people to pursue the existing European permanent residency under the UK rules. So there's lots of reasons why individuals do want to move to the UK, clearly not for the weather, but otherwise there's lots of other reasons why we want to. A lot move for education reasons, being able to educate. The UK does have a very strong education system. Tax planning, political and legal stability for a lot of individuals, financial security, and mobility and ease of travel. It's really just, I popped on a flight early this morning and here I am in Europe. It's fantastic. So lots of great things in terms of offering from a UK perspective. So I wanted to talk a little bit now around the actual immigration categories that are useful to have just a broad understanding of when you're looking at how you want to either come to the UK or suggest for clients to come to the UK. So back in 2008, the UK announced what was called a points-based system, and that was multi-tiered. Tier 1 really is the ability to come in sort of self-sponsored. So you have a Tier 1 investor and a Tier 1 entrepreneur. Both I'm sure that we've all heard of before. Over the time, they've been tweaked and changed slightly depending upon political, the political agenda and the public demand, etc. And also, some of them have been, widely subject to fraud in some instances. But this is just to give a bit of a trend in terms of what we're seeing with respect to the Tier 1 investor category, and I'll talk a little bit more about what the requirements of that are in a few moments. But you'll see that we're still getting, obviously for 2016, it's not huge amounts of people by any stretch of the imagination, but just in terms of the top 5 countries, China still by far, outweighs Russia. It used to be many years ago that Russians were very much the ones that dominated in terms of the Tier 1 investor market, but now we're obviously seeing more and more Chinese. The last sort of ones is really just in the first half of 2017 what we have seen. And whilst it's not it's still, I think, going to be a lot more applications than it was for 2016. I do find it interesting that at least we've got 10 Canadian applications which are higher on the agenda. Not sure why, but I just thought that was an interesting little fact. So what do you have to do and what are the requirements in terms of getting the Tier 1 investor? The threshold changed. Back in before 2014, it used to be you only had to invest £1 million. That's since increased to £2 million. There are rumours, and there are certainly individuals and financial institutions pushing the UK government to actually increase that from 2 million to 5 million, or in fact 10 million. At this stage, I think the government is pushing back on those, but there is a little group that's suggesting it should be higher than the 2 million. I quite like the 2 million where it is personally. But you have to invest 2 million by way of government bonds, share capital or loan capital in active trading UK companies. We see, in fact, a mix of clients obviously doing all of those things, but I'm also seeing more and more individuals investing in, like coming in and buying almost their own company, investing in their own company, providing it's a UK, which is perfectly acceptable. There's a lot more sort of paperwork around how you maintain the portfolio and the valuations, etc., of that company. But that's something where we are seeing a bit more of a trend rather than people just coming in and putting the money directly into the, say, government bonds, which, don't yield very much at all. So that's quite interesting. One of the new requirements, or relatively new requirements, is that in order to access a Tier 1 investor application, one of the things you must now do is open, before you can even submit the application, a UK-regulated bank account. Now, it's hard enough for individuals with, a status in the UK, like a proper immigration status in the UK, to open a bank account. And we have seen various challenges in terms of high net worth individuals wanting to try and open that bank account. It's really about marrying the individual to the right bank and depending upon how it goes, but it can be actually quite tricky. And if you can't get over that hurdle, you can't get over any of them, unfortunately, from a Tier 1 investor perspective. The 2 million has to be maintained for a period of 5 years, and we'll talk a little bit about the accelerated program in a minute. And of course, the big catch, which again I've had lots of discussions with lots of investors around the residency requirements, thinking it is just way too onerous for a lot of individuals, particularly true individuals that have multiple businesses around the world, and they just want this either for ease or they want to just be able to have the Tier 1 investor to have access to their children, being able to access the schools, etc. But from a residency requirement, they really have to spend half the year in the UK, and half the year means physically feet on the soil at all times. Depending upon the application and the family and how it looks, how things work out, it's quite often that we might make the main applicant, say the wife, for instance, who's going to be actually spending more time, and that would give, say, the husband more time to be able to travel around the world and not having to strictly meet that residency requirement. But it is tough. People ask, is there any way around it? No, is the short answer at this particular time. There's a couple of fast-track options. So the 2 million, if you were to invest the 2 million, you are able to apply for indefinite leave to remain after a 5-year period, and providing, obviously, you meet the residency requirements. So the indefinite leave to remain is the same as permanent residency. Once someone's got permanent residency, they're obviously free to be able to do whatever they like with those monies. They no longer have to keep them invested in the bonds or the share capital or whatever. They can move them around more freely. But you still must hold, from the time you get that indefinite leave to remain, you still must hold it for 12 months before you're able to apply for British citizenship. If you invest more, you can get the indefinite leave quicker. So, for instance, 5 million, you can apply for indefinite leave to remain after the 3 years. 10 million, you can apply for it after 2 years. The kicker, however, is that whilst they accelerate the indefinite leave to remain route, the citizenship rules have not changed. So that means that you still must have spent at least 5 years and had ILR for 1 year in the UK before you can apply for citizenship. So the more you invest doesn't mean the quicker you get a British passport, unfortunately. It does mean, though, that you're able to re-access your money and be able to use that money more freely. Some clients are still happy with that, and you still would need to meet the same residency requirements after indefinite leave to remain is obtained in order to look for getting that British citizenship option, if that is something of importance. Recently, we've seen quite a few challenges with respect to the investor route. So just a couple of examples here. They're getting a lot tougher, basically, in terms of the provenance of the funds. Where are they from? How are you getting them? And the other thing I think is really interesting is sort of like the due diligence as well. So if you have a client or if there's anything quite untoward on the internet with respect to that individual who may have allegedly committed some sort of tax evasion or a fraud, it does become a lot more difficult in order to sort of get them over the line. So as part of the things that we do, we also pretty much run a full security check and really draw out any information for our clients to make sure that we can address those when we submit the application. Half the time it's usually unfounded and untruthful, and it's about making sure that we're able to address those at the point that you make the application, which I think is critically important. The other thing which I find is interesting, so the deed of gift, and we've seen quite a few experiences of this. So quite often if we're switching, say, from the husband to the wife and we gift them the $2 million, etc., sometimes those applications or the spouse is very, very reluctant to do a deed of gift because it must be irrevocable. And quite often after the 5 years, there's been several instances where, unfortunately, being in the UK, which has great divorce courts, by the way, is a great location for the parties to separation, of course, because the gift is irrevocable. It does become a bit of a challenge in getting any of that money back. So again, just something to be wary of. So the second type of sort of self-sponsored visa for individuals to come to the UK, you're looking at the Tier 1 Entrepreneur Visa. Again, this is a great visa for individuals, but there's a couple of sort of hurdles that you really need to get over in order to be able to access it or make the application successful. It's a much higher used category, and that just gives you, again, an idea of sort of the countries and the trends that we're seeing at the moment. Again, very high from a China perspective. India is much higher as well in terms of the entrepreneur visa, and that's understandably so because the level of funds you require for the entrepreneur is in fact much less. So what do we need? 200,000 is pretty much your broad brush figure in terms of looking at an entrepreneur visa. You can reduce that to 50,000, providing that there's an endorsement from like a seed fund, etc., in terms of supporting that particular business. You will need to create 2 jobs within that 5-year period. So you'd be issued a visa initially for 3 years, which is then extended. But during that 5 years, it's really important that you are able to create 2 jobs for settled workers. In most instances, that's absolutely fine. In fact, there was a case that came out this week, which I think was, really quite sad, but it was a really lovely family doing a Tier 1 entrepreneur. They'd been there for 5 years. They, in fact, had created numerous jobs, but the regulations state it must be in that last sort of 12-month period, that last 5 years at the moment, and they didn't meet it. They had met job creation throughout the whole of the 5 years, but they just missed out on that last bit. And they owned numerous homes and etc. And the court just ruled that nope, you didn't meet the criteria and therefore you're out. So it's really important that if you're going to go down this route, that all your clients or really understand the nuances of every single part of the Act, because the government is really quite strict and are not allowing any sort of, taking into account any sort of human element. Even if you have met the requirements, they really are ticking all the boxes. The individual will need to become a director of the business within 6 months. Again, that's a pretty easy tick from that perspective. And they will look in terms of the growth. So a couple of things to really pick out of this. In terms of the application process itself, it's about the individual. You have to first of all prepare a really solid business plan and submit as part of the application. And that will need to show how you're going to invest that $200,000 and what it's going to look like over that 5-year period. But the individual also has to be someone that is an entrepreneur or really has an idea and can show, that he has the correct, or he or she has the correct talent and to be able to achieve that. So much earlier on, the Home Office was even looking at, say, LinkedIn profiles, and if they didn't think you were appropriately matched to this particular job as an entrepreneur, they would refuse the application. So they do look at the individual, and quite often you are asked for an interview, you're asked a series of questions, and it's really important for them to be able to demonstrate their business savvy in order to get this particular type of visa. The reason why it's so tough is there was, in fact, quite a bit of fraud that happened with the Tier 1 entrepreneurs, so that's why they've really sort of closed down on it. So you had lots of very, very clever students in the UK, and they'd group all their money together and show that they had a big 200,000 pot, and then as soon as someone got the visa, they sort of moved it on, and someone else had 200,000 and they moved it on. So that's just sort of one example of the level of sort of fraud that occurred and why they're looking sort of so tightly in terms of the Tier 1 entrepreneur at the moment. But it is a really good option for people who are genuinely coming to set up some form of business, and it can be any sort of business as well. Same sort of requirements or for the Tier 1 entrepreneur. You can absolutely obtain indefinite leave to remain after the 5-year period. There's a faster route where you can obtain indefinite leave to remain after 3 years, again, if you meet the criteria of having either 10 new full-time job positions for settled workers in the UK. And a settled worker is someone that is either British, European, or it could be a non-EEA individual who already has indefinite leave to remain in the UK. Alternatively, it can also be that if you have a net increase of income from a business activity of at least 5 million during that initial 3-year period, again, you can have a fast-track route to 3 years. And again, that's really... It is important for clients, if they are able to do that fast track within the 3 years and they tick all the boxes, absolutely we would recommend that they're able to do that sooner rather than later. It just gives you, again, then freedom to be able to know that you've got that indefinite leave. They're able to make sure that they can then do whatever they like with their business. Some people I know have sort of been quite cautious in their approach to their business until they've got their indefinite leave to remain, and then they'll look at taking a little bit more risk to either elevate them, and quite often that's a success. But when you've got a noose hanging around your neck from an immigration perspective, sometimes people aren't as willing to take as much of a risk in terms of what they want from their business perspective. So just a couple of things to weigh up in terms of which application may or may not be beneficial for your clients. I mean, clearly, both of them have significant differences in the amount of value that's required, or the amount of money that's required. So in addition to the $200,000 from an entrepreneur perspective, they also need a little bit more cash to evidence maintenance. That would be for themselves, plus any dependents that are coming in with them at the same time. They don't need any maintenance requirements if you are an investor. Very similar requirements, sort of like in terms of the residency and how long you have to be there. But one of the other big differences is the English language requirement. So for an investor application, for your initial 5 years, you do not need to have an English language, which is a great thing for individuals who, obviously English isn't their first language and they don't want to learn it. For the entrepreneur, it's mandatory that they have an English language and they meet the English language requirement from the first instance. And that makes sense as well, because if you're going to be running a business, you should be able to speak English. One of the things, though, that's always a challenge for some of the investors who think, great, I don't need to meet the English language straight away, is that it is mandatory, though, for citizenship. So if citizenship is important to them, again, it's important they get the right advice to make sure that even though they may not want to learn English in the first instance, during that 5-year period, they will definitely need to have a few lessons and get themselves ready if they do want to do that citizenship option at the end. The other really good option to come in is a sole representative visa, and this is great for businessmen and high net worth individuals who may already have businesses in or outside of the UK, and they want to come into the UK and set up another business and have sort of like a wholly owned subsidiary of an existing business that they have. It is a category that's used quite a lot by lawyers, but not sort of widely out there in terms of sort of public knowledge. But ultimately, it really is designed, though, to send more of a senior employee rather than the owner of the business, someone that's going to go over there and start and create and add value. But quite often it is a very good route, potentially, say, for a child or an overage dependent child who may already be working in the business back home, wherever that may be. Being able to bring them in under the sole representative category is a great way. It's a cheap option. There's no mandatory money requirements in terms of spend. They do need to show that they're able to sort of act autonomously and make decisions. And then there's a few things that they would need to do. For instance, they will need to be able to set up the company as soon as they sort of arrive within a certain period of time. They can bring family with them. And this route also leads to indefinite leave to remain, providing they again meet the residency requirements and thus citizenship after a period of 6 years. So it is a good alternative when we're sort of scratching our heads trying to think, what are we going to do with those, say, overage dependents? I sort of just spoke all about that, but I'll leave that there just for a minute. Tier 1 exceptional talent. That's another great, I was going to say relatively new. I mean, it's been around for a few years now. But this is really for individuals, and again, it can be, business people or high net worth individuals. But it's really for the creme de la creme of the world. It's so that the UK remains open and tries and attracts the best skills from anywhere around the world. I think it's a category that's probably is underutilised, if I'm being honest. It really is, at this stage, we know it's used quite a lot by the tech industry, but even to get it, they've got quite stringent requirements, and you have to have, really world-known or world-known sort of like recognition in terms of the thing that you've designed or whatever you've been working on, or you might be like an amazing ballerina or something like that. And you also do need to jump through a few extra hoops, and that's mainly, the first one is that you need to be endorsed by a designated competent body, and the list of the bodies are down here. But you need to, first of all, if you were to make an application, send various documents which meet very stringent criteria, and then they will assess your talent. If they assess that you do meet the relevant criteria, then you would get an endorsement and then be able to sort of move through to apply for the visa. Ultimately, though, again, it does amount to indefinite leave to remain, so the time spent in the UK can obtain indefinite leave to remain and then citizenship, but it is, again, a really useful way of coming into the UK. This is talking a little bit about the technation. It's probably not as relevant probably for this particular audience, but this is where we're seeing probably more individuals coming to the UK, and obviously there's a significant government focus on bringing in as much sort of tech talent or startups as possible into the UK, and this is a great way of being able to bring it through. I'll just talk very briefly about Tier 2 of the points-based system, and this is really where employers sponsor individuals to come over. So most times it's not really relevant from a private client perspective, but actually we're seeing more and more companies come over, so they may in fact use, say, the Tier 1 entrepreneur to bring a couple of people over, or we also may use that in combined with a Tier 1 a sole representative application. But once they're there, they might want to bring other individuals over, and that's where they would need, as a business, a sponsor licence to be able to bring over those non-EEA migrants to help support. And again, this could be, family members, it could be other individuals that are key to, say, their business in overseas, and we would use the sponsor licence option. It is heavily regulated, and the UK VI, or the Home Office, quite often come out and do spot checks in terms of all the companies that do have sponsor licences. It's quite strong in terms of making sure that you know who you're employing and that you're not employing anyone illegally. We do a lot of work around sort of due diligence and audits for many of the clients just to make sure that they do keep well up to date. But the thing that drives the sponsor licence or the Tier 2 around bringing the individual in, again, whilst this is an employer-based system, it also can be self-assessed. So it's about sponsoring individuals that meet a certain salary requirement and a certain skill set, and providing they meet those sort of criterias. In some instances, there may be advertising required, so that you may have to go out to the resident labour market and make sure that there's no other individual that can do this particular job. But usually, you're able to bring in the migrants in terms of that sponsored element. Here we talk a little bit about sort of the thresholds in terms of sort of some minimum salary requirements. Each of the positions, in fact, must meet what they call the threshold of an NVQ level 6, which is usually quite a high sort of degree. And it's not the individual that needs to meet that, it's the role that needs to meet that. And so what we quite often need to do is map the role itself to what they call a standard occupation code, and then we have to make sure that the salary meets the relevant thresholds as well. So a couple of pros and cons in terms of why individuals do want to come to the UK. Very much sort of similar, I guess, to why people want to in one of the earlier slides. Taxes is a big reason. So currently 20%, possibly reducing to 17%, or possibly reducing to 15%. But there is a lot of good tax-type regimes from the UK. We've also found that a lot of people come to the UK from a legal perspective, very much because British law is very transparent and there's a separation of powers doctrine, and they quite often like to contract under the UK as well. Now, they don't need to be resident to do that, of course, but we do find that sometimes clients are very that they like to be able to have that flexibility from the British court system should anything go wrong from a business perspective as well. So that's a very high-level overview of sort of the main features of the UK immigration law. Does anyone have any questions or thoughts? Otherwise, thank you very much for your time. Oh, yes, sir, sorry.
Yep.
Yes, sorry. Yeah, thanks for the presentation, by the way. It was interesting. In the entrepreneur visa, what is the percentage of success? Number of applications, number of people actually get it?
It really depends on the country that you're applying in. So, for instance, if we're applying from the US, I mean, I think it's a very low percentage that are not rejected or refused, whereas there's a very high refusal rate in countries such as Russia, India, China, African countries. So really important to be able to make sure we've got all our ducks in a row before we submit.
Thank you.
Thank you very much for this presentation. You raised a very interesting point about the impact of Brexit on the immigration, and I have a question about the children born in the UK. Here in France, we have the right, if you are born in France, you have the right to get a French citizenship automatically. I was wondering about the children born in the UK. Do they have the same right, or do they benefit from some special conditions in terms of citizenship?
Yeah, absolutely. So for children born to European parents in the UK, it is not an automatic right to British citizenship. The parents have to have been there for 5 years and show that they have had permanent residency. Now, the children themselves who are born in the UK don't need to show permanent residency. Once the parents have that permanent residency, the children are then entitled to register as British citizens. And those applications take around about sort of four months. So they are entitled to be British, but they have to register to do so, and the parents need to have got that permanent residency. The child themselves, though, do not have to have lived there for 5 years. So the child might be only 6 months old when mum and dad get permanent residency, and that's fine. We can then register the child for British citizenship at that point in time.
Okay, thank you for your presentation.
Lovely. Thank you very much.
Katrina Cooper,
Thank you.
Director of PwC.